Hello. Thank you, leadership. My lords on the dais, my lords of the dais, distinguished participants, ladies and gentlemen. We have just had a very fascinating story on what technology can do and what technology can, how technology can be so deceiving. Because for the last 2 days, what we have been witnessing is the scope of technology in the courts. And now in the last, my preceding speaker has very easily dismantled all the concepts of infallibility which has been created for the last 2 days. And with this, with the permission of the chair, I'll start my presentation with a story of a global injustice which almost got perpetrated because of the infallibility of technology which was perceived. It's a real story from United Kingdom, from England. A very famous story on which a number of web series, movies, and serials, they have been enacted. In around 2000, all the post office in England, they adopted a new software which was known as Horizon software. That was an accounting software. Immediately when the software was adopted, after 5 years or 10 years, a number of accounting errors started coming in. And the postmasters who were handling them, around 900 of them, not one or two, 900 of the postmasters, they were prosecuted. They were prosecuted for fraud, for committing defalcation of money, running into billions of pounds. 256, around 250 people were jailed, and some committed suicide. Some people also, their lives were ruined. But there was a person named as Ellen Bates who took up the fight on behalf of all these postmasters. And then there was the expertise of Lord Justice Fraser, a judge of England and Wales High Court. The technical expertise of the Honorable Judge of the England and Wales High Court, he produced a beautiful judgment, a judgment which is titled as Ellen Bates versus the Post Office, 2019, England Wales High Court, 3408 Queen's Bench. This judgment tells us that technology is not infallible. Even if there is digital technology, it has to be taken with a pinch of salt. With this background, and with the important information and fascinating information that we have just received, I will take up the practical challenges, the challenges which will look into a sort of criticism, but it is not a criticism, but it's a mirror check as to how all the app, all the e-Saksh, and all the technology that we are talking about, how it is performing in the courts. And that is why we are all concerned, because it is the court is the last person, as one of the speakers have already told. It is the last receptor. And every institution, be it the police, the prosecution, everybody is working for producing it for the courts. I will take up the issues of challenges. I will also take up the issues of the roadmap. I will take up issues of how to have the capacity building from the perspective of a court. This may come across as a dry subject after such a fascinating speaker, but then I'll seek your ears. The very first point is, everybody has talked about interoperability of the system, and they have talked about the 5 pillars. 2 years have already elapsed. We are into the second year, and still we are talking about the integration of the system. And why I'm saying so? The law does not demand excuses. The law will not excuse because 2 systems are not integrated. We will not have a judgment coming out of an honorable court or of a trial court that since the systems were not interacting with each other, so he is absolved. The law will demand real evidence. The law will demand the technical requirements. And let me talk about the first app, e-Saksh app. For the last 2 days, so much have been said upon it. And I'll take up a very basic question. There are around, as per the data of SCRB, 30,036 videos that have been uploaded on it. Agreed. There are 22,000 investigating officers who have already been registered. Agreed. Now what happens to those videos? Section 105 mandates, as Honorable Ladyship has already said, it is a must provision. Section 185, it talks about search and seizure by an investigating officer of SHO. That is a must provision. So what happens to all these videos which are lying stored? Because we are not integrated with it. Will the trial court stop looking at the videos? I'm talking about the practical consideration. The videos are there. It is an evidence. And under the new laws, it is a document. It's not electronic evidence, it's a pure document. So my first question is, under section 230 of the BNSS, corresponding to section 207 of the CRPC, every accused person is entitled to a copy of the document that on which the prosecution relies. It is must. The Honorable Supreme Court, as Ladyship has pointed out, the judgment of P. Gopalakrishnan alias Dilip versus State of Kerala, 2020, Volume 9, SCC, page 161. And prior to that, Tarun Tyagi versus CBI, 2017, Volume 4, SCC, page number 490, made it explicitly clear that if there is electronic evidence, a copy of it, and not a simple copy, not an ordinary cut copy paste, but a cloned copy of that has to be provided to the accused mandatorily. Where is that mandatory provision? Where? Because today, the court are yet to get the document. When the court itself is not getting the document, how will the court supply that document to the accused person? This is the first question. The second question is, under the new laws, the onus lies on the police explicitly. Earlier it was implied, now it is explicit, to produce as many copies of police papers as there are total number of accused. So I ask a question. The videos are lying there, and the director of the NIC, the learned director of the NIC, he said that steps are being taken that the other actors like accused, witnesses, etc., they will be formed apart. So what happens to those trials which are pending today? Will we say to the accused person, since in your case the app is yet to be developed, so you will not get police papers. You will be deprived of that. And will our constitutional courts accept that? Will the trial court accept that? That is a challenge. There lies the question. What happens to those trials? Because we are already 2 years into the provisions. This is a question. We move to the next part, again in the e-Saksh, and I'm talking about the practical experiences of many of the trial court judges of whom I have interacted on this subject. You know what is happening? The investigating officers, the police officers, sadly to say, they go there, they record the evidence as it is. And there are instances, what happens is that IO who goes there, he takes up the cell phone, he records it through e-Saksh app, and then he uploads it. What is the relevance? What is the value of such an evidence? Yes, we are saying that the investigating officers, the prosecutors, they are being trained. But is the question of being trained will be allowed over the legal requirements? What will happen to the evidence which has been produced by an untrained investigating officer? What happens to those cases? These are questions that cannot be left open. We have to answer it. This is the first challenge. I don't know of a solution. But the next challenges that are before us, ahead of us, I will also try to give some of the perceived answers that I believe. And the second one forms the core of the entire presentation. It is about the challenge of digital, how do we interpret the digital evidence? There is multiplicity of digital evidence, WhatsApp chat, everything is there on. Every person moving around with a cell phone is having some sort of digital evidence. How do we translate it into reality? I was told that everybody now knows that there is a requirement of a certificate when there is a secondary evidence. But yes, let me remind you, which was reminded yesterday by Honorable Justice Joymala Bagchi, sir, that now there is not requirement of one certificate. Be absolutely clear. There is requirement of 2 certificates. It has been made explicit in Pune Bar Association versus Union of India, writ petition number civil 599 of 2026, decided on 22nd of May 2026. It's a recent judgment. And among the points that Honorable Lordship yesterday told, the second important point was the constitutionality of second certificate was challenged, which was upheld. And it was held that it is a mandatory provision. Wherever you are giving first certificate, you have to give a second expert certificate. The only thing that was diluted is this second certificate need not be given by Ministry of Information and Technology labeled expert, but it can be by any ordinary expert. That is the dilution that has been done for all of us. And here I am reminded about Lord Cecil MR's famous dictum in Taylor versus Taylor, which has been quoted by Honorable Supreme Court in n number of judgments, in almost every judgment on electronic evidence, that if the law mandates a particular thing to be done in a particular way, it has to be done in that way and in no other way. That means the technical requirements which are there explicitly mentioned in section 63(4) has to be followed by the prosecutor, the police, howsoever grave the crime may be. You cannot take excuse that, see, I don't have second certificate, still you go ahead. Now coming to this certification part, there is another very important point which I believe everybody must understand is contemporaneous certificate. Earlier it was delivered by Honorable Supreme Court, that it was part of judgment. Now it is part of law. That every time when an electronic evidence changes its hand, every step, you need to have fresh certification. And if that is missing, what will be the consequence? Could be a question. If a certificate is incomplete, what will be the consequences? And that has also been answered by the Honorable Supreme Court of India. That if a certificate is incomplete, Smriti Madan Kansagra is a case law, 2021, volume 20, SCC, page number 421. That if a certificate is incomplete or it is a partial certificate, it means no certificate. So the challenge before us is that it is not only about the certification, it's about a complete certification that needs to be given to the courts. If you want your electronic evidence to be presented and to be admissible. And here comes the second question. Most of the prosecutors, investigators, and some of us as well, believe that the moment the certificate is given to us, that electronic evidence, now we'll have to accept it as it is. But the answer is no. You don't have to. It's just the threshold. A certificate along with an electronic evidence in case of secondary electronic evidence only means that this is an evidence which now you can read. This doesn't mean that you have to accept as it is whatever the contents of the electronic recorder. Then what is the answer? The answer earlier was in the judgments of Honorable Supreme Court, started with Anwar PV versus PK Bashir, the very celebrated judgment, and now it has been explicitly made part of the BNSS. Section 193, subclause 3, more subclause 1, point I, 193.3.1I. It says that at every step there has to be a chain of custody. That is one step. And what about the other? The other is mentioned in Schedule 1 and Schedule 2 of the Bharatiya Sakshya Adhiniyam. And that is the hash value, which we also call the fingerprint. How to calculate it? It's very simple. It's very simple. If you have a photograph, if you have a video, you can have n number of websites. You just need to give a link to it. It will immediately create a value. And there are numerous mathematical values. And my expert will correct me if I'm wrong. You cannot reconstruct an audio or a video from that hash value. Hash value can give only one time number. Means you cannot reconstruct an audio or a video from a hash value. I hope I'm correct. So that is contemporaneous certificate.
So can I just add one point? A lot of people get confused between encryption and hash. So now, for example, if you have a 1 GB file, which you want to send it on WhatsApp, it encrypts it and it sends it there so that nobody can read it in between, and only the person who has got the decryption key can decrypt it. So the size of that file will be 1 GB only, or maybe a little more. But when you're hashing something, even if it is a 1 GB file, the hash value will just be one line. Even if it is a 1 TB file, the hash value will be just one line. It is only to check whether that file has been tampered or not. You will not get the original document back no matter what you do from that one line that you have got of that particular file. So therefore, we don't have the term called dehash. We only have encryption and decryption. Hash, that's all. You just get a value. But one mistake which everybody does is when they take the hash value, they don't mention which algorithm was used for taking the hash value. Whether it was SHA-1, SHA-3, SHA-256, SHA-512, you just give the hash value there. We will not get to know, looking at the hash value, which algorithm was used. So therefore, we have to mention very clearly which was the algorithm used and the hash value.
Sir, on that algorithm part, there is a specific requirement now under Bharatiya Sakshya Niyam that has to be, there is a box of SHA-1, SHA-256, MD1, MD5, all these. In fact, that has to be clicked. So I request all the prosecutors, the police officers, that when you are submitting this certificate, please ensure, as Anand sir has said, that the exact box also needs to be clicked, because I have already told that in Smriti Kansagra case, the Honorable Supreme Court has said that an incomplete certificate is no certificate. So that is another point. Now, I will not dwell much upon it. The third challenge that we believe in electronic evidence is, which now the investigators will come, because we have section 105, 185, 176, where it always talks about electronic evidence, is if an electronic device is obtained from an accused person, can a person be forced to disclose his password? If an investigating officer comes before you and says that that accused person is not giving his password, he's having an Apple phone which is we cannot crack, can you force him? This is a question which was answered by two of the Honorable High Courts in India. And Honorable Karnataka High Court in Virinder Khanna versus State of Karnataka and P. Gopalakrishnan alias Dilip versus State of Kerala. And they have answered in affirmative. They have said that yes, an accused person can be forced to part with his password. These are two Honorable High Court judgments. There is no conclusive Honorable judgment of Honorable Supreme Court of India. As far as Delhi High Court is concerned, there is one line single reference in Hitesh Modi versus CBI that an accused cannot be forced to part with his password. So this is a question. There are two judgments on one side. There is one judgment on one side. The Honorable Karnataka High Court discussed all the constitutional judgments, 11-judge bench, and it concluded that one has to give password. Now the third important point that I immediately want to take up is actual physical handling of the digital evidence in the court. Almost all of us who have been in the trial court and who have seen electronic evidence, they have seen the compact discs being, tied up with the CD, tied up with the records. And you will be surprised that this compact disc has been tied from the middle and it cannot be used in any sense. You have been given a pen drive in a simple way which is hanging from a record, which you don't know, which can immediately be data be erased. You have all these kinds of shortcomings, and apart from that, all those who are trial court judges who are handling excise matters, there may be 10,000 plus matters, even more than that, where the only evidence is the breath analyzer report. And the breath analyzer report is printed on a paper, of which the printing of which gets immediately vanished after 4 months, 5 months or 6 months. As a registrar list, I can see even in bail matters, when a photocopy of that is presented, that is almost a blank photocopy because the data is already erased. Now I shudder to think what will happen when after 1 year, 1.5 years, when the trial will actually start, what will be the evidence before the court? The record which is printed on it is already cleaned. You have a blank sheet of paper. So there needs care, there has to be some sort of infrastructure where you are going to save, and that infrastructure is to be immediately created, where you have to save the electronic records, because electronic record, as Prabhu sir and everybody knows, is so fragile that even if for a moment that CD or a pen drive is left, it can immediately, the contents can be changed. And imagine a pen drive contains the CCTV of a murder case and the contents have been deleted. And that is the evidence before you. What happens? There is no copy left. So these are some of the concerns which concerns the physical infrastructure of that. Now coming to the next challenge, immediately I'll take up, that is about human resources. Yes, everybody right from the judges to the prosecutors to the police officers, they needs to be adequately trained about the technical requirement is because for the first time they are seeing electronic evidence coming up in such a big way. People, even lawyers, everyone, they are used to seeing documents as the primary evidence, documents. Here what we are having is electronic evidence, and the nature, though it is defined as document, but the nature of a paper and electronic evidence is way, way, way different. So we need to tell our investigators, prosecutors, ourselves, that we need to have a special expertise. And I may say, like we have Modi's medical jurisprudence as a standard textbook in all the law libraries, we can also have Stephen Mason's electronic evidence in all the libraries. That is an urgent requirement, so that if each one of us who knows contusion, abrasion, and concussion, they must also know what is hash value, what is date stamp, time stamp, and hashing. These are the challenges, and in this entire exercise, we are forgetting one of the most important pillars, that is the defense lawyer. Our experience says that defense lawyers have absolutely almost no idea of electronic evidence in most of the places. Now, how will that accused be protected? How will he cross-examine him? So there is a requirement. We need to have there has to have some sort of training program for these defense lawyers as well, so that the right under Article 21 is also legally protected. Apart from these challenges, we talked about infrastructural challenges. I will not speak on the infrastructural challenges because the Honorable High Court and the state government and the central government, it is taking care of. It is going to provide us with the laptops or with the necessary infrastructure. So, with these words, as far as roadmap is concerned, we'll take up some other day. But again, I return back to the last point which I made is the Horizon software case. It was not a story of despair. The story told us that if there is resilience, the story told us if that we are having the expertise, we can also undo the injustice that has been done. And I believe with the adequate amount of training on BNSS, BNS, and BSA, we, all the integral part of the criminal justice system, we could take up our state, we can take our state at that high level, and we can also achieve the instrumentality, or we can achieve the highest ideals of justice using technology and all other tools that are being provided to us. Thank you so much. Thank you.